Okay, this section of the ethics code is about confidentiality and privacy. It's section B in the ACA ethics code. Um, it's different in the APA ethics code, but the material is pretty much the same, and I've addressed both in this presentation. So the reason that we discuss confidentiality is because we have to respect clients' rights, and clients have the right to determine when they disclose and to who, and they enjoy the basic right to privacy that they deserve. So one aspect of this is that it's not your job as a counselor to solicit information from them that is not pertinent. So let's say you're working on, you have a client who's there who's working on bereavement, right? Maybe they've lost a spouse or a child, and you're just kind of curious about whether they ever experimented with drugs in college, let's say. Well, you might be curious about that, but it's not pertinent to treatment, and therefore it's not really your right to ask, or how many sexual partners they've had, or things that don't have to directly do with what you're working on. It's not your job to ask, and it's also not your job, and actually it's very unethical for you to talk about your clients with other professionals or with other people in your life without consent. We'll talk about subpoenas and things like that, but in general, you should not be discussing your clients with other people. Now, when we talk about consultation, you may discuss your clients in a very abstract way with people that you consult with without giving them any identifying information. So I'm in a group text with some girls that I went to graduate school with, so we're all licensed psychologists now. We live all over the country. But we'll text each other with a screenshot of some scores, for example, from an IQ test, and say, hey, what do you think about this? Or how would you address these scores? Or do you guys know of any good treatments for, childhood depression that are accessible to parents who are lower functioning? And that's okay. We are talking about our clients. I'm not saying I have a 6-year-old who grew up in this town, and hey, you might know their parents because they also went to this, school, blah, blah, blah. None of that, right? And even with my husband is a licensed psychologist as well. We live in a town that we live in Ardmore. It's where he's from. And so often he'll get calls about doing testing cases or something for someone that he knows. Maybe not well, but he went to high school with them or whatever. And he'll refer those to me because I don't know them and I have a little bit more of a clean slate. And I can't then talk to him about those cases because he knows them. He would know who I'm talking about, and that's not okay. Now, if I just say to him, hey, do you think that um, a kid with autism would do this, right? Because he has training, and I'm not saying age or gender, and I test when I'm not teaching, like in the summer and stuff, I test 2 or 3 kids a week. And he knows that. And so it's not identifiable to him who that person is. But in general, we don't gossip about clients. We don't seek out information we don't need. We don't do those things. Also, prospective clients. So let's say someone calls you and says, I have a pornography addiction. Can you help me with that? Well, now you know the name of this person and that they have, kind of a serious addiction issue. Even if they don't come to you for treatment, you don't share that news with anyone else. It's not okay for you to say, hey, guess who called me today and apparently has a problem with porn, right? If they called you in good faith, that you would not be gossiping about them. You tell clients in that initial informed consent meeting under what circumstances you would break confidentiality. The main ones are child abuse. So if you're working with an adult and they indicate to you that they are abusing their children, neglect, abuse, sexual abuse, any of those things, or if they themselves are a child and disclose abuse to you, you would break confidentiality. Also, if they express to you that they are going to harm someone, the ruling on that is called Tarasoff. Tarasoff was the name of um, a victim of a client in California who, the client had disclosed to his counselor, who was actually under supervision, that he was having homicidal thoughts about his ex-girlfriend. He ended up killing her, and the counselor, he actually did tell his supervisor, but the supervisor did not take adequate steps to protect that potential victim. And so Tarasoff has become the name of the court rulings that have come out about protecting identifiable victims. So if someone says to you, I'm thinking about um, I'm thinking about murdering my ex-husband, and you talk to them about that, and they are serious, they've thought about a method, they have means, um, then it's your responsibility to warn that person or to get the police involved. That is an exception to confidentiality. Same thing with calling DHS if you suspect abuse. If the client is thinking about hurting themselves, so they are suicidal, they have means, you believe them that this is imminent, you have the right to break confidentiality and call 911 and get them stabilized. It's not absolute. You can't promise that no matter what, no one will ever see the records that I'm keeping right now, because you don't know that. You don't know that you won't get a court order down the road. You don't know that, but you do make reasonable steps, and you explain to them what your intentions are as far as confidentiality. When I write reports, I test a lot of kids, I tell the parent, I'm going to write this report. I will keep a copy. I will give you a copy. I will not send that report anywhere without your consent. So I'm not going to automatically send it to the school or to their pediatrician without their consent. I won't say no one will ever see it but you, because if I get subpoenaed, someone might see it, right? I'm not going to say that, but I will say I will do everything in my power to keep it between us. And I also give them fair warning. Anything you tell me will go in their report. Sometimes parents tell you things like they smoked marijuana while pregnant. Well, if they tell me that, I'm going to include that in the report, and now it's in writing. And now anybody who sees that report because they're a special ed director at that kid's school is going to see that. That's not breaking confidentiality. They told me, and it's an important piece of the puzzle potentially for why this child is the way they are. Um, that's something I'm going to include. I won't include necessarily, long um, sidebars that sometimes people get into about how messed up their marriage was, and this is why they got divorced and all that, if it's not pertinent, right? But exposure to toxins while pregnant is pertinent if you have a child who has delays. So all of that needs to be explained up front. So the actual legal exception or ethical exception to confidentiality is written here for you. When it's required to protect clients or identified others, like a identified threat, from serious and foreseeable harm, or when legal requirements demand, like a court order, that you give over your records, you should still always consult, make sure that you're doing what you're supposed to do. Your liability insurance will have people that you can talk to, lawyers who are on retainer who you can talk to about court orders and subpoenas and things like that. And you make sure that you document any consultation that you get. But those are the exceptions, and sometimes you won't have time. If someone says, I'm going to go shoot this person when I leave here, you're not going to wait and call your liability insurance and all those things. You're going to call the police before they even leave. If they have kind of abstract homicidal ideation, like I would like to shoot up a church. Let's just say they say that. You document that and you talk about that, but that's different than saying, I am going to hurt this person or this church at this time, right? Because people say things sometimes and they don't mean it. If they say, they're going through a messy divorce and they just say, I wish they would just fall off the face of the earth. Well, okay, that's fine. That's different than saying, I'm going to poison them. I have it in my car right now, right? And so it has to be the language here is serious and foreseeable harm with an identifiable victim. So not kind of abstract, like it's possible that he could run someone over just for the fun of it anytime he gets in his car. What are you supposed to do about that? Uh, so I would still consult, document consultation, but there's not an identifiable victim. So when a client is suicidal, when a client threatens harm to identifiable individual or group, when the counselor suspects neglect or abuse, it could also be another vulnerable adult, like a elderly relative they're taking care of, or someone with a disability, um, a sibling with Down syndrome or something. It doesn't have to be a child as far as C goes. And then just be familiar with those duty to warn and duty to protect laws. Ours are pretty standard in Oklahoma as far as what your responsibilities are when it comes to child abuse and reporting, those type of things. If you end up working with clients who are chronically ill or very old, then the idea of assisted suicide may come up, or even not assisted suicide, just regular suicide. It's imperative that you know what the rules are in your state, because you can become complicit and there can be legal consequences to that. Oklahoma is a very conservative state, which I know is shocking to you, but you may be held legally responsible if someone tells you that they're going to, let's say, overdose on their pain medication because they have cancer, and you don't do anything about it. So just be aware of that. Most states that have those laws, they don't actually end up prosecuting the clinicians who knew, but they could. If their parent or maybe their family could civilly sue you for knowing and not doing something about it. So there is um, a link here in the notes. You can look up what each state's rules are about euthanasia. But again, I would put that legally and ethically at this point in the same camp as any type of suicidality, that it's your job to protect them from themselves. Even if you may have some personal views that they should be allowed to do what they want, legally you can still be held responsible. If the client discloses to you that they have a life-threatening disease, usually we're talking about STDs here, like HIV, the rules for confidentiality here can get bent a little bit. So first, you need to find out if there are identifiable people, victims, who are at risk. So if they are HIV positive and going out to the clubs, or they're on Tinder every weekend, that's not an identifiable potential victim. What are you going to do? Follow them to the clubs, watch their phone? No, you're not going to do that. You would still talk to them about potential risk and about, how you can talk to potential intimate partners about HIV. But if they are, let's say, in a serious relationship with someone and that person doesn't know, then do you have the right to break confidentiality? And again, there's a link here. You can look up different states. If there is a clearly identifiable victim who does not know and who will be harmed, in Oklahoma, you have the right to tell them. And you can look up the actual laws here, but if they're living with someone, or they've been dating someone for a long time, or they're married to someone and they're HIV positive and they haven't told them, you almost look at it as if they are a potential murder victim, because that's essentially what's happening. They are inflicting on them a potential life-ending condition. Okay, this is it's in italics because it's straight from the ethics code. It's important that you're clear on the language here. So court order disclosure, when ordered by a court to release confidential or privileged information without permission, first you seek consent from the client. So you get a court order, let's say it's a custody case, and you're seeing one of the parents. First you ask them, hey, the judge asked me for my records. Do I have your permission to send them? So first you try that, because if they say yes, then you're fine, right? If they say no, then you try to limit disclosure to only exactly what they ask for. Again, because a court order is not something you can deny. A subpoena from a divorce lawyer, you can say, I don't have consent to send that to you, and that may get you out of it for a little while at least until the judge gets involved. Once the judge gets involved and it becomes a court order, you can go to prison for failing to comply with a court order. So you may have to submit your records. However, you may not need to submit everything. With assessment cases, you may have to send them your final report. You are not obligated to send them protocols, for example, because protocols are copyrighted material. They don't need to fall into the hands of people who don't know how to interpret them. And so there are some loopholes or some kind of mitigating circumstances here to what you have to send. But when circumstances require the disclosure of confidential information, you only send what's essential. So maybe you send the records that you have about their parenting in a custody case. You maybe don't send the fact that they disclosed to you that they were raped when they were 13, because that's not pertinent to who should get custody of this child, right? If there's no current issues with sexual abuse or anything like that. So you are obligated, just like every other citizen, to respect the laws where you live. But sometimes you should, limit what you say, try to keep the client informed of what's going on so they're not blindsided. And if you do get into a position where you have to testify, even if the client says no, then you are very particular about what you say and how much you say. You really don't want unnecessary disclosures. With subpoenas, so a court order comes from a judge, a subpoena comes from a lawyer. You do have to treat it seriously. You cannot ignore it. But ethically, you are allowed to wait and not respond immediately. So you don't just get the subpoena and the next day send all the records. You can consult. You can make sure you talk to your ethics liability insurance attorneys and make sure that the subpoena is valid and that a response is required. If they determine that the subpoena is valid, then you figure out what is the minimum level of response that you can send. You might be able to just get by with sending a summary rather than releasing everything. You can't delete things or what's it called when they black things out? The word just slipped my mind, but redacted, redacted records. But you might be able to kind of negotiate what's really important to send. It does not require you to follow the law regarding responding to a subpoena, but you may get in trouble if you don't, right? You're then accepting the potential consequences of not responding to a subpoena. It's kind of a matter of conscience, right? Like civil disobedience versus following the law to the letter. And that's how that goes. But I would always consult with an attorney, understand that a subpoena is different than a court order. You can't ignore either one, but you can maybe have a little bit more wiggle room with the subpoena as far as how in-depth your records need to be. Also, within any type of practice, especially if you have more than, like if it's just you in a one-room office and you do all of your own billing, then this isn't as much of an issue. But if you're in a group practice, the secretaries, office administrators, billing staff, they're going to know things about your clients. because they're going to be sorting your notes, they're going to be submitting the billing, they're going to be handling the requests for records that come in, and it's important that they understand confidentiality as well. Also, if you are part of an interdisciplinary team, like you work in a practice that has a psychiatrist, a counselor, a social worker, an MD, a general practitioner, a nurse, then it's important that the client is aware that you will be discussing them with those people. I contracted for a couple years with DDSD, Disability Services in Oklahoma, and we would meet monthly with each client's team. And that team was usually a nurse, me, the case manager, the PC, which is the agency's representative, for whoever's doing their in-home care or staffing, their primary caregiver, maybe their guardian. And the clients were aware. Now it gets into a little bit of a gray area when the client is not competent to give consent, because these are people who have an IQ below 70, but they were aware that teams were meeting on their behalf. But even those meetings need to be happening in a confidential setting, right? We're not meeting at Starbucks to talk about these people. We're meeting at DHS, or we're meeting at the agency's office. The door is shut, those kinds of things. As far as third-party payers, which would be insurance, they will get some information. They will get a billing code, which will include a diagnosis, and they will include the time that you saw them, how long you saw them for, that kind of thing. They're not necessarily privy to the day-by-day progress notes. Medicare, for example, and Medicaid require treatment plans. So they may see kind of abstractly what you're working on. So-and-so is working on coping mechanisms to help them make, better decisions. That's different than so-and-so disclosed this to me today, and now, Medicare needs to know. So who'd get consent. As far as sharing information, there are ways to protect how records are sent. There's some HIPAA compliant emails that allow you to encrypt records that you send or require a password to open them. Faxes are still considered to be secure, which is a little bit ironic because you never know who's at the receiving end of the fax machine. But and then one other point about that is that when a client dies, it does not mean that confidentiality ends. So just because your client dies doesn't mean that you can then talk to their parents or their siblings or their spouse about everything you knew about them. You still respect their confidentiality. For those of you who are interested in doing groups, like drug and alcohol groups, anger management groups, parenting groups, or working within a family system, it's really important to know that there are limits to confidentiality in that setting. You cannot guarantee that no one in the room is going to ever talk about what they've seen or heard in that room. You can talk to the group, and you should talk to the group about the importance of privacy, but you can't guarantee what anybody else is going to do outside of that room. With a couple or a family, it's going to be different. If you bring in the whole family from day one and you're doing systemic therapy with them, the whole family then is the client, right? But if you're seeing an individual and then you start bringing in their children or their spouse occasionally, the client is still the client. And everybody else in the room is just a piece of that puzzle, but their confidentiality or the expectations of their confidentiality is different than the client who you got informed consent with and all of that. And that all needs to be explained to everyone involved. And the case analysis gets into that a little bit, so we'll talk about that. But in general, if you're seeing a couple for marriage counseling or a family consistently, then they as a unit are the client. If you work with minors or incapacitated adults, then they can't necessarily give legal informed consent. They can give assent, which is you've kind of broken it down to them on their level, and they say okay, but there still needs to be someone who can represent them and have their best interest say, okay, this is acceptable. So counselors are careful to protect confidential information, um, just like you would be with anyone else. If you're seeing minors, uh, there sometimes are situations where they will disclose things to you that you have to decide whether or not you tell the parent. And um, that is a case by case situation. You would tell the parents up front, I will not be telling you everything that I hear, right? It's not your job to be the informant on this child or this adolescent. However, I will also tell you if your child is in danger, because then we're getting back to those confidentiality rules, right? If a 15-year-old discloses to you that they are having sex with their boyfriend and they are using protection and um, all of those things, it's going to be a judgment call on your end if that constitutes danger, if that constitutes breaking confidentiality. Ideally, you encourage them to talk to their parents about it, but they may not, and then you're in a situation of what constitutes the individual making decisions that are literally putting their life in danger. If they're smoking pot occasionally, that's different than if they are drinking themselves into a blackout with strangers on 3 times a week, right? So it's tough. There's no clear cut, black and white, you know, situation with this. I would always if possible, tell the client before you break confidentiality so that you can maintain some integrity. They're going to be pissed if you tell their parents and they don't want you to. But at least if you give them warning, they're not blindsided. And hopefully you've told them ahead of time, hey, I'm not going to be a snitch, to your parents. However, there are circumstances under which I will have to tell them what's going on. And those are primarily if you disclose to me that you are engaging in things that are dangerous for you. And we would describe dangerous as life-threatening. So it's a fine line. It's really tricky, keeping that balance between them trusting you versus you protecting them from themselves when necessary. And so that can be very tricky. When it comes to documentation, it's your job to secure confidential information. There used to be a 2-key rule. So the file cabinet is locked and the room is locked. Kind of gotten away from that in this world of electronic record keeping. But you make reasonable strides to keep things confidential. So is it possible that you have records on your laptop and your laptop gets stolen? Yes, that's possible. That's different than you leaving it open at Starbucks and the people are walking around and you have people's confidential information, out and about. Anytime that you're going to record or have someone else in the room observing, you have to get permission ahead of time, signed permission. And then what does the client have access to as far as your records go? So the rule is you provide reasonable access to records when requested. So they want to see their progress notes, then you can give them those. Now, there's a difference between the official progress notes that go in the client's file versus your personal notes, which I would keep separate, which are kind of your thoughts about what's happening. So in one place, maybe you have, on February 2nd, client disclosed husband was having an affair. In your personal notes, maybe you say, maybe you make notes about like, was this the first affair? Are there concerns about your client exaggerating or your client being paranoid. That doesn't need to be in the official record. So you would limit access to even their formal official file if it would cause harm to the client. So if, for example, you're working with someone who has paranoid schizophrenia and you indicate that in your notes, but if they see that, they're going to then think that you're just like everyone else who doesn't believe them and maybe cause them to go into a little bit of a spiral. The rules change a little bit. Always document the request for records and any rationale that you have for withholding records, besides just, I don't think they need to see that. Because it's their records, their brain. They have the right to see what you're writing about them. So anything else you have about another client, things like that, they don't get to see. Ethics code encourages reasonable future access. So again, you have your, for me, for example, I have my reports saved on my computer. I have them also on a backup external hard drive, right? That's kept locked. Now, if the office catches on fire and my laptop is burned, as is the file cabinet that has the external hard drive in it, that was reasonable attempts on my part, right? That, I mean, I can't control everything. If you discard of files, let's say it's been 7 years, and that's your agency's rule for discarding files, you shred it. Obviously, you don't just put it in the trash with your, your fast food lunch. And then anything with child abuse, suicide, sexual harassment, ethics complaints, I would just keep. I would just keep it. I wouldn't get rid of it. Keep it until you die. When it comes to designing an office, there are things you can do to help ensure confidentiality or ensure to the best of your ability, kind of that reasonable attempts. Soundproofing as much as possible using white noise. Don't leave client records out. Train your extra staff, like your secretaries and billing staff, on what to say and not say to each other and to other people. How you respond to requests for information. Be thoughtful about technology. Don't use Gmail to send records. Be careful what you leave in messages. So you could say, this is Dr. Roaring returning your call. It's calling back at your earliest convenience. That's fine. You wouldn't say, this is Dr. Roaring. I'm wondering if you've smoked any crack today, right? You got to be judicious about that. And only use texting if they're comfortable with it. Okay, let's talk briefly about the case analysis that was due last week. I'm recording this before the due date, so I haven't seen everyone's yet. But just some things to think about here. So we've got someone in private practice. She's been working with this client for several months. He came in for depression, and he has some kind of emotionally intense responses to things. Dr. Ives thinks that it's possible that he might have some kind of cyclic mood disorder, which would be like bipolar disorder. He admits to her that he has some anger management problems, and recently he described physically intimidating his wife and pushing her down. So he's reporting that he's progressing. She's working with him on strategies to calm him down. One day she gets a call from his wife, and she leaves a message and says that he's become more physically intimidating and started to push her around. She's not significantly harmed, so she's not, in fear for her life or breaking her arms or anything like that. But she would like to come in and explain what's happening. At this point, Dr. Ives has only met with her informally in the waiting room, has not had a formal session with her. So there's the situation. There are a lot of things to consider here. First of all, who is the client? Right? The client is the husband. What are the potential harmful consequences of breaking any type of confidentiality here? So even if the wife calls and says, hey, I just want to make sure he showed up today. Do you have the right to call her and confirm, yes, he came today? No, you don't, because she's not the client. Now, if he has signed a release for her to get access to records, it's a different story. But in this situation, we can assume that no release has been signed. So you've got a potential domestic violence situation. You know that domestic violence is likely to increase, right? And so she may be at risk for potential future danger. However, I do not believe this meets the threshold of identifiable homicidal type thoughts unless he has said to you that he has fantasies about killing his wife or something like that. She does not need to come in and talk to you unless he wants her to, because he's the client. So I think another part of this dilemma is, do you tell him that she called? If it's going to piss him off more and put her in danger, you don't want to do that, right? So I think that would depend a lot on, I mean, this is obviously 3 paragraphs and you're not actually in this situation, but you can maybe bring it up to him. Hey, would you be open to having a joint session, and not mention that she called, and just see kind of what his reaction is. If he's adamantly against it, I think that tells you something about where he's at in that process. As far as calling her back, I think calling her back with resources for domestic violence, just like you would anyone who called you and left a message and said they were feeling unsafe, is fine. But I do not think it would be appropriate in this scenario, given what we know, to disclose what you know that you've heard from your client in a confidential setting. It's not fun. It's tricky. As a woman, I would feel some allegiance to the to the woman. I'm just being honest, and want her to be safe, obviously. But as a clinician, my client is Mr. Gray. Mr. Gray has told me that things are getting better and that he's working on these skills that we've been working on. He's my client. So again, this is where ethics is tricky, and there is not always a clear-cut best choice. But you don't want to alienate him and then him not seek any more treatment, and now she's a victim and he has no coping skills, right? So there's just all kinds of factors to consider. But the short answer is, he's the client. You don't get to break confidentiality unless there is a foreseeable, identifiable victim who is in serious danger. She has not indicated to you that she's in serious danger. And you might try to get him to take the first step toward involving her in treatment, and you can give her resources that you would give to anyone else who is questioning their safety. And that's about it. And it's not easy, that's for sure. So as we go through the semester, you'll see multiple examples of how tricky ethics can be. And that's why it's so important to kind of follow that ethical decision-making model. Think about other consequences, think about who you would consult in these situations, and try to arrive at the best solution possible, which may not be a good solution. The best solution may still be kind of crappy, and that's how these things go. So I'm very lenient with grading the first case analysis. The main thing is I want to see how you thought through it, not necessarily that you came up with the quote-unquote right answer, because sometimes there is not one. But it's still important to just kind of think through it in a systemic manner. So thanks, guys. Our next lecture will be hopefully live via Zoom. Assuming all goes well on my end, I will definitely keep you updated on that. And let me know if you have any questions or concerns.